Board California Panel D's meeting, January 26th. And we want to go ahead and call the roll call. Michelle, thank you very much.
Ms. Lawson?
Here.
Dr. Nardi? Here. Dr. Kraus?
Present.
Dr. Levine?
Here.
Ms. Pines? Here. Ms. Sutton-Wills?
Here.
Dr. Bolak?
Here.
We have a quorum.
Thank you very much. And today, this morning we welcome our Judge Lynn Willard, who will be presiding over this panel.
Good morning. We are on the record before the Medical Board of California and Office of Administrative Hearings, case 2016-120987. This is the date, time, and place set for oral argument regarding the proposed decision issued in the matter of the accusation against Andrew Mark Posett, MD, agency case number 800-2015-011543, Office of Administrative Hearings, case 2016-050999. My name is Marilyn Bullard. I've been assigned to preside over this matter, and as we've just indicated for the record, there is a quorum. May I take the appearance first with from the Deputy Attorney General?
Good morning, Supervising Deputy Attorney General Jane Zach Simon.
And for respondent?
Good morning. Adam Sloat of Sloat Links in Borman, for respondent Dr. Andrew Posselt.
All right. Before I go any further, I've been asked to encourage all the panel members and participants to be sure you're speaking into your microphone so we have a good recording of the process. Thank you. In this matter, the board has issued an order of non-adoption of a proposed decision issued by Administrative Law Judge Anderson, and it has decided to determine the matter for itself. The board has instructed that oral argument should be directed only to the question of whether the proposed penalty should be modified. The strict time limits will apply. Respondent will begin and will have 15 minutes to make an opening argument. The Deputy Attorney General will then have 15 minutes for a response. Respondent will have 5 minutes for a closing argument, and similarly, the Deputy Attorney General will have 5 minutes for a closing argument. I'll try to give you a 2-minute warning. The arguments in this matter shall be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that would elicit new evidence. The administrative law judge and any panel member may ask a party to support the party's oral argument on a matter with a specific citation to the record. At the end of the oral arguments by counsel, I will offer Dr. Posett an opportunity to address the panel directly, and if you elect to do so, I'll place you under oath, sir. After oral argument, the board will go into closed session to deliberate. The parties will not receive a decision today, but it will be received by mail in the future. Again, please remember that all arguments must be based on the existing record and no new evidence will be heard. The board has already had the benefit of reading in your briefs. And Ms. Simon, I know that you're stepping into this for Mr. Chalmers, so I just want to advise you that there has been a discussion about complainant's brief that was filed, argument that was filed by Mr. Chalmers. Specifically, there's a footnote 2. It appears to incorporate new evidence, and he's attached some additional documents as an exhibit to that argument. That appears to violate the rule for no new evidence, so the panel has not reviewed that and will not consider that. However, if in fact that was part of the record and you care to address that in your comments, you are free to do that.
Okay, thank you.
Thank you. All right, so let us begin then now with the respondent. You may begin your presentation. Do you have a question, sir?
Your Honor, before I start my argument, I would like to address the issue of the additional evidence, the document that was attached to Mr. Chambers' his written argument. Because my concern is that it puts us in an unfair position. You can't unring the bell. Members of the board have seen the footnote. They've possibly read the documents attached. And it's incomplete information because UCSF sent an additional letter to the medical board to explain the situation after that, and that was not included. So it's only fair that the board members, to the extent that they have this in their mind, this 805 report, that they get to see the whole 805 report and then decide perhaps to disregard all of this evidence as improper evidence. But right now, we have been put in a very unfair position.
Ms. Simons, do you care to respond?
Your Honor, there was this was something that was discussed in our office, and we were mindful of the order stating that no new evidence would be considered. But it did seem to be something that, a report that was made by law to the medical board pertaining to this incident, and it did not, ultimately, it did not feel right to essentially withhold this information that was not available at the time of the hearing because the report had not yet been filed, albeit the action had been taken. So if Mr. Sloat wishes to, I'm not aware of an updated report that was filed. I don't doubt that there was one. But if Mr. Sloat wishes to include that, I don't have any problem with it. But it does seem like information that, had it been available at the time of the hearing, if the board had known about it, it might have been something that the board should know about.
Do any of the members care to comment on whether they have reviewed the footnote and the attachment in preparation for today's hearing?
Are you asking whether we've seen
Yes.
it? Yes, of course.
All right, because we did have a discussion about it yesterday. So at this time, I believe it would be appropriate to allow respondent to do that if you do have an additional document, and that I think will perhaps present the panel with a complete picture.
If I could just take a couple of minutes to explain the situation, because the Medical Boards Council certainly had a footnote that explained it from their perspective. So I'd like to
You can proceed.
explain it from our perspective first, and then I have the copies. Would you like me to present that
Why
to you
don't you
first?
present the copies at this time?
So, Judge Willard, what I'd like to do is, I'd like to explain our position and then move to strike the entire topic, because I think that's the appropriate way to address this issue. So then the members have heard from both sides, and then they are able to disregard this additional evidence fairly.
You can proceed, sir.
I just want to make clear I wasn't waiving my objection to this additional document.
I understood.
So first, the document that was attached to the argument, Mr. Chambers' argument, is an 805 report from UCSF that reports the restriction of Dr. Posselt's privileges. Because UCSF has privileges and employment as separate issues at their facility. First, I'd like to explain the restriction of privileges. As a result of this case, UCSF assigned Dr. Posselt to see a therapist weekly for 6 months and to test for alcohol with a handheld SoberLink device on a daily basis. Dr. Posselt completed 4 of the 6 months of this. There's been no problem. There's been no positive tests with the SoberLink device. And in 2 more months, this restriction on Dr. Posselt's privileges will be removed. Dr. Posselt is in a vicious circle because this case caused UCSF to restrict his privileges. They were faced with the medical board saying that Dr. Posselt was at risk and a danger to the public. So management at UCSF got involved based on that. Now, the Office of Attorney General is arguing that the medical board should restrict Dr. Posselt's license because of the UCSF action. So this is the circle that Dr. Posselt is in right now. Now, the letter that I provided gives more explanation to the original 805 report. And with that, I request that you exclude this whole matter from consideration.
Ms. Simons, do you have a response?
Yes, there was discussion at the hearing, and I refer you, the board, to page 120 of the transcript. Dr. Posselt was asked by his counsel about his reappointment to the UCSF medical staff, and he said that his reappointment was kind of awaiting the outcome of this case. But in fact, UCSF, in the letter that Mr. Sloat has just submitted, says that they reported based not on the medical board's action, but the report was submitted out of an abundance of caution for an incident that occurred in or around January 10th, 2015. It wasn't in response to the medical board's action, and indeed, the UCSF action took place in August before the medical board hearing and certainly before the medical board's decision in this case. So to the extent that it does clarify the testimony that was given by Dr. Posselt in the hearing, it was our office's determination after a great deal of consideration that it was information that the board should have to have a complete picture of and an accurate picture of the facts and events in this case. It was Dr. Posselt who brought up in the hearing his status at UCSF, and based on the 805 report and now this December 6th letter or December 8th letter that council has submitted, I believe there is a complete picture before the board at this time, and I think that it is relevant. And council has now had a full opportunity to explain Dr. Posselt's side of the story version of events, and I believe that it is fair and appropriate for this panel to consider the information.
Any further brief comments, Mr. Swan?
Yes, I mean, some of the information that Ms. Simon provided is not the complete story, because this process, this requirement of the testing and the therapy wasn't resolved until after the hearing, and it wasn't started until October. The hearing was in September. So, you know, Dr. Posselt didn't have his meeting to know what was going to happen to him with the brass until later. And the people who were in his department wrote letters and testified for him. Those were the people who he works with. His supervisor wrote a letter. Those people were not issuing this requirement. This was coming from higher up. And so it's just a very misleading situation, because the University of California is a very large organization. And when they're confronted with the serious allegations made by the medical board, there are people in that organization who feel they should take action.
At this time, the motion to strike the evidence presented in the complainant's brief is granted, and as well as the letter that was presented. I do understand that it's hard to unring the bell, but I think the rules provide clearly that additional evidence cannot be provided, and this opens up the slippery slope of further facts, further facts, further facts. So the decision will be based strictly on the record, as is the rules for this proceeding.
Thank you.
At this time, respondent may begin his 15-minute program.
Members of the board, Dr. Andrew Posselt is a professor at UCSF and a board-certified surgeon specializing in transplants of the kidney, pancreas, and liver. He was convicted of driving under the influence of alcohol a misdemeanor. The incident occurred on Dr. Posselt's week off from work. I ask you to consider the following sentence. There is a difference between a doctor who gets a DUI driving home after a shift versus a doctor who gets a DUI on the way to the operating room. That was the testimony of the Director of the Department of Consumer Affairs, Awet Kadane, last summer before an independent state oversight agency known as the Little Hoover Commission. Director Kadane was discussing the fact that not all DUI convictions are substantially related to the qualifications, functions, and duties of a physician. Reform of licensing agencies is being driven by criminal justice reform. When a doctor is convicted of a crime, punishment is the responsibility of the criminal court, not the medical board. This has been decided in the Court of Appeal in the case of Ettinger versus Board of Medical Quality Assurance at 135 Cal App 3rd, 853, page 856. The accusation alleges Dr. Posselt's present or potential unfitness to practice medicine in a manner consistent with the public health, safety, or welfare. But the witnesses at hearing testified that Dr. Posselt is an outstanding surgeon and that he has never shown any indication of impairment. At the hearing, a forensic psychiatrist on the faculty of UC Davis testified that he evaluated Dr. Posselt and determined that he does not have an alcohol problem and that he is fit to practice medicine. Administrative Law Judge Mary Margaret Anderson presided over an administrative hearing where 7 witnesses testified. Judge Anderson has 17 years of experience, and she was specially trained and selected for the medical quality hearing panel. The Office of Attorney General requested that Judge Anderson revoke Dr. Posselt's medical license, stay the revocation, and impose terms of probation that include urine testing and a practice monitor. Judge Anderson rejected the allegation that Dr. Posselt is unfit to practice medicine without supervision, and she ordered that Dr. Posselt be publicly reprimanded. Judge Anderson's decision should have ended this case, but a legal technicality permits the agency to throw out Judge Anderson's decision, and I argue that this puts you in the unfair position of making the final decision without hearing the witness testimony in this case. Now, the order on non-adoption requests oral argument on whether the penalty should be modified. But this is not an honest question. Rather, this is an invitation to the Office of Attorney General to ask you for a harsher penalty, because the agency knows that we asked for a public reprimand, and the agency knows that the administrative law judge issued the public reprimand, which is essentially the minimum penalty. So the question is just really, shouldn't we increase the penalty? Now, an agency's power to overrule the administrative law judge stems from a recognition that regulatory agencies have expertise in complex areas such as nuclear medicine, nuclear energy, telecommunications, and medicine. But this case does not involve complex medical questions. And the only medical question decided by Judge Anderson was that Dr. Posselt does not have an alcohol problem. At hearing, this was undisputed by the Office of Attorney General. So in this particular case, it would be an abuse of discretion to reject Judge Anderson's decision. Dr. Posselt is the director of the UCSF Pancreatic Islet Transplant Program. He's the director of the UCSF ABO Incompatible Kidney Transplant Program, and he's the co-director of the UCSF Bariatric Surgery Program. He's a gifted surgeon. In fact, he's the only surgeon west of the Mississippi River who performs autologous islet transplants to to cure severe pancreatitis. But to truly understand Dr. Possel's passion to save his patients, we need to look at his interest in a more mundane procedure, the laparoscopic sleeve gastrectomy, which I'm going to refer to as an LSG. An LSG reduces the stomach size for weight loss. Bariatric surgeons do not work on high-risk transplant patients, and few transplant surgeons perform the procedure. The reason this matters is that obesity disqualifies many patients who need liver or kidney transplants. Across the United States, there are patients who face death because they cannot lose weight. Weight loss is difficult enough for healthy people, but it can be nearly impossible for a diabetic who suffers from cirrhosis of the liver. In some of the finest hospitals across this nation, obesity is often a death sentence for a transplant patient. I'm proud to say that Dr. Possel raised the standard of care in San Francisco by learning to perform the LSG on obese transplant patients so that he can reduce the stomach size of the patients and cause rapid weight loss so the patient can qualify for a transplant. Dr. Possel is the only surgeon at UCSF who does this procedure on transplant patients. The record shows Kaiser Permanente has a bariatric surgery program but sends its transplant patients to Dr. Possel. Sutter also sends its transplant patients to Dr. Possel. Dr. Possel advocates for the use of this procedure at conferences across the world. He trains UCSF fellows, and he has patients on a wait list for the surgery. Now, as a person, Dr. Possel is 54 years old. He has been married for 16 years, and he has led an exemplary life. He graduated from Stanford for undergrad, the University of Pennsylvania for medical school, and his PhD. He did his residency and fellowship at UCSF. But Dr. Possel is not perfect. In January of 2015, he mistakenly drank too much beer at a party for his son's sports team, and he drove home. Dr. Possel was on a week off from work. He was not on call. The morning of the incident, Dr. Possel went on a vigorous bike ride on Mount Tamalpais. He then took his son to the game and then to the party to celebrate the end of the season. He never ate lunch. At the party, there was food for the children, but not for the adults. Unfortunately, one of the parents ordered pitchers of beer at this party. Dr. Possel drank beer from a glass without paying attention as people refilled his glass. By the time he left to drive home, he had no idea he was intoxicated, and none of the other parents said anything to him. During the 10-minute ride home, the alcohol took effect. As Dr. Possel rounded a hairpin turn on Hillside Road, he took the turn too wide. He hit a parked car. That parked car hit a parked car in front of it. And fortunately, nobody was injured. At the time of the accident, Dr. Possel had his son in the right front passenger seat because the seats were down in the back for his bicycle. His son was very upset and screaming, so Dr. Possel decided to take him home and then return to speak with his neighbors about the damage he had caused. Dr. Possel parked his car directly in front of his garage and took his son inside the house. Within minutes, the police showed up and they saw the damage on the car right in front of his house. They confronted him, he confessed, and he was arrested. Dr. Possel admitted driving the car, causing the accident, having his son in the car. He pled guilty in court and completed the terms of his sentence. Judge Anderson described Dr. Possel as honest and forthcoming from the beginning and very remorseful. She stated his behavior was out of character and clearly an aberration in an otherwise law-abiding life. She concluded, given the totality of the circumstances, it is clear that the risk of reoffense is very minimal. The public will be sufficiently protected by issuance of a public reprimand. This case presents a legal conundrum. Dr. Posselt faces discipline for a mistake in his personal life, but a mistake in the practice of medicine is not cause for discipline. That requires gross negligence or repeated acts of negligence. The solution to this conundrum is to limit discipline to crimes where there is a true substantial relationship. Finally, I ask that you consider the potential harm to patients that could result if you restrict Dr. Posselt's license as requested by the Office of Attorney General. This would require Dr. Posselt to leave the hospital twice weekly on a random basis to provide urine samples at a First Lab collection facility. When an organ becomes available for transplant, Dr. Posselt may face a 12 to 18-hour stretch in surgery and post-surgical care. This means that he cannot comply with these typical probation restrictions. In addition, restricting Dr. Posselt's license, or any physician's license, automatically terminates their status as a Blue Shield provider, and this can affect patients' ability to receive care they need. There was a full and fair trial in this case. I urge you to accept Judge Anderson's decision, and thank you.
Thank you. Ms. Simons, this is your opportunity to speak to the board.
This is one of those unusual cases where the facts are really not disputed. Dr. Posselt, an otherwise fine man by all accounts, drove when he was very drunk with a child in the car, crashed into some parked cars, fled the scene of the accident, and was thereafter convicted of driving under the influence of alcohol with a very high blood alcohol level of nearly twice the legal limit. Given the facts of this case, the ALJ's proposed decision correctly found that these facts constituted cause for discipline for unprofessional conduct by virtue of the fact that on that day in January 2015, Dr. Posselt used alcohol in a manner dangerous to himself and to the public, and he put the public at risk of serious harm. It was also determined, and this is based on the case law that makes it clear that this is so, that this conduct and the conviction resulting from this conduct was a conviction that is substantially related to the practice of medicine, albeit it did not occur at the hospital or in the actual course of his medical practice. I think that these are facts that, as a matter of law, there's not a lot of room to argue them. I believe the ALJ, and in fact, I don't believe Dr. Posselt himself has argued that the conviction and the facts underlying the conviction are cause for discipline because he is satisfied with the issuance of the public reprimand that the ALJ concluded was the correct result for this case. Indeed, the only real penalty, and the board has identified that in its order of non-adoption, is what is the appropriate response by this board to the single DUI involving a high blood alcohol level, not just a 0.08 or a 0.09 where you are technically legally drunk, but when you are very drunk and you are driving a car in a manner and using alcohol in a manner dangerous to the public. Now, before we get into the nitty-gritty discussion about the actual penalty, I wanted just to address briefly a couple of points that were raised by respondent in his brief and in his argument. First, Dr. Posselt argues that this really is not an appropriate case for non-adoption because non-adoption should be reserved for those cases involving actual technical medical expertise of the board. There is no authority for that, and the law is very clear. The board always has, it is the board's decision, and it is this board which must decide what is the appropriate response to factual and legal findings that are adduced following a hearing. There's no distinction between cases that involve the technical expertise and just the expertise and responsibility vested in this board by the laws of the state of California. Dr. Pacel's brief also argued that he is somehow placed in a very unfair position and has been denied due process because he doesn't know who voted to non-adopt or what the reasons for that decision were. Again, there's no authority cited for this proposition because no authority exists. And in fact, the law is and has been for many, many years to the contrary. There's nothing in the Administrative Procedure Act or in any other California law which requires the board to provide its reasons for non-adopting. And according to the leading California treatise on this subject, the California Administrative Hearing Practice Handbook published by the Continuing Education of the Bar, and I quote, "The parties are not entitled to know the reasons," end quote. The board is clearly entitled to deliberate cases in its closed session function, and it has done so in this case quite properly. Dr. Pacelt has also cited to the board a string of other cases in which a physician has been convicted of a single driving under the influence count, and says that since those cases were decided with a public reprimand, somehow this case must also be cited in the same manner. Once again, no authority for this proposition is cited, and again, that is because the authority is to the contrary. The actual law is that when it comes to the board's considerable discretion in fashioning the appropriate disciplinary order, and in particular the terms of discipline or the penalty, there is no requirement that charges similar in nature must result in identical penalties. And I'm quoting from a case which I can never pronounce the name, but I think it is Pegues, P-E-G-U-E-S versus Civil Service Commission. Now, having dealt with those, what I would call misconceptions that were set forth by a respondent, I'm going to now turn to the real question, which is, what do you do with this case? And I think it's important to note at the outset that a lot of the cases that come before the board dealing with alcohol and other substances are cases involving what we now call substance abusing licensees. And this is not one of those cases. There is no evidence that Dr. Pacelt is what we would call a substance abusing licensee, and the evidence is to the contrary. He simply is not. But that isn't the only kind of case that the board has to deal with. It's not a zero-sum game. It's not either you are a substance abusing licensee or there are no concerns regarding alcohol use. And in fact, the legislature has said that when a licensee uses alcohol in a manner dangerous to himself or to others, that is cause for discipline. That's the category of licensee that we are dealing with in these single high blood alcohol level DUI cases. So it doesn't mean that we should have no concern for the alcohol abuse that took place in January of 2015. And I think what we have to do, always the first place we go when looking at penalty, is the board's published disciplinary guidelines. And we've had the terms arbitrary and capricious, abuse of discretion tossed around today, but it is those guidelines that keep this board from acting in what the law would consider to be an arbitrary and capricious manner. And it is for that reason that the boards do everything that they can to use the guidelines to fashion disciplinary orders so that people are treated fairly and so that the public is treated fairly and is protected. in cases involving substantially related convictions and in cases involving conduct which poses a danger to the public, a public reprimand is not the customary result. It is not listed in the range of guidelines. It's certainly within the board's discretion in a given case, but to do a public reprimand in cases involving a substantially related conviction, the board has to be satisfied that this significant downward departure is warranted in these type of cases. And I would suggest to you that this may be perhaps the only type of conviction where the board has in the past frequently adopted this kind of downward departure. So I'm not going to tell you, and I wouldn't presume to tell you that you need to exercise your discretion in any particular matter. I'm just suggesting that it is a decision that bears considerable thought before it is done in this case or routinely. We have stated in our briefing, and we stated at the hearing, that it is our belief that this case warrants a period of, probably a short period, but at least a period of monitoring and oversight with terms and conditions designed to not only ensure that Dr. Pacel's use of alcohol was in fact an isolated incident and is not going to reoccur, but also to reinforce the message that use of alcohol in a manner, driving when very drunk, with a child in the car, being involved in a hit-and-run accident, is simply not conduct that is acceptable, and it is unprofessional conduct. I would suggest that a revocation stayed with at least a short period of monitoring with terms and conditions related to abstaining from alcohol, biological fluid testing, which again is not a uniform standards case. The board can fashion an order that takes into account that the frequency of testing may not have to be precisely what it would be in a uniform standards case, and most certainly completion of a professionalism program would address the public perceptions concerns that are raised given the facts and the findings of the substantially related conviction and the use of alcohol in a dangerous manner. Thank you.
5-minute response available to respond.
Thank you, Your Honor. So I want to talk a little bit about the authority, the legal authority that Ms. Zach Simon referred to for the discipline against a physician based on a single DUI. Because the Medical Practice Act, section 2239A, says in it that more than one misdemeanor conviction related to alcohol shall be conclusively presumed to be substantially related. So clearly the code did not anticipate the idea that a single D, doesn't say a single DUI is substantially related. Now, it says, and Ms. Zach Simon referred to the code 2239, where it says use of alcohol in a dangerous manner is also unprofessional conduct. But what's very important, and you have to really read the code carefully, 2239A very carefully, is that conduct under 2239 has to be substantially related. So use of alcohol in a dangerous manner is only cause for discipline if it is substantially related. Now, there is a conclusive presumption in 2239 that certain conduct is substantially related, and one of those situations would be multiple DUIs. That would be conclusively presumed. So let's talk about the Griffiths case, which is the case that Ms. Zach Simon is referring to, which is Griffiths versus Superior Court, a 2002 case at 96 Cal. 4th, 757. Now, this is the board's authority for the action they take against doctors with a single off-duty DUI. But nobody talks about what actually happened in Dr. Griffith's case. Dr. Griffiths was driving under the influence 3 times. Each arrest was within 2 to 3 years of the one before. At the time of Dr. Griffiths' first arrest, he was under the influence of prescription drugs as well as alcohol, and the arresting officer required help from a passing citizen or multiple passing citizens to handcuff Dr. Griffiths. At the second arrest, Dr. Griffiths was still on probation for the first case. At the time of the third arrest, Dr. Griffiths exited his vehicle yelling, "Due process!" He identified himself as an attorney with the ACLU who had been set up because he had defended Rodney King. He went to jail for 4 months. He was not an attorney with the ACLU. Now, the key in Griffiths was this prior medical board at the time's determination that Dr. Griffiths had not demonstrated any insight into the reasons for his action, nor had he made sufficient efforts at rehabilitation. Now, this is a very different case from the case of Dr. Griffiths. This is a case of a single mistake that's not substantially related to the practice of medicine, and Dr. Posselt has demonstrated insight. You've read his testimony. So I did not ask the ALJ to dismiss this case, as Ms. Zach Simon said. I asked for a public reprimand because it was my objective for Dr. Posselt to get back to work as a physician, not to be fighting this in the Court of Appeal. But I do not believe this case is cause for discipline. I do not believe this case is substantially related, and I have argued that in Superior Court, and I have a decision of a Superior Court judge in Sacramento saying that a single DUI is not substantially related, which is not precedent in this case, but I've raised this because Ms. Zach Simon said that I conceded the point, and I have a history of not conceding the point, of always arguing this point.
Counsel, the focus should be on the penalty.
The idea of the penalty that's being requested has no indication. It's like a prescription for medication that is not indicated. We're talking about testing somebody with random drug tests, essentially. These are tests that test for drugs and alcohol. These are tests for somebody who has an addiction problem, somebody who you're trying to make sure is keeping off of the alcohol and drugs that they were addicted to. Treatment is a requirement for somebody with an addiction problem.
Time is up. Ms. Simon, do you have any response?
No, Your Honor, I believe our brief and argument has said all we have to say.
All right. And Dr. Posselt, do you care to address the panel?
Sure.
All right. Please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give in this proceeding will be the truth and the whole truth?
I do.
Thank you. Please turn the microphone towards yourself.
I obviously have never been in a situation like this before. I just wanted to say that it was, the event that happened was a horrible mistake on my part. It's been the worst thing that's ever happened to me, and over the last 2 years, it's been difficult building my family back together again, which it affected, and trying to keep my job going, which it also has affected. I made a terrible mistake. I'm sorry. I don't have an issue with alcohol. It was a terrible mistake when I was not paying attention. That's all I can say. Sure. I'm a transplant surgeon, as you know, and that requires, I'm sure all of you know, long periods on call where you're going to be called whenever, you don't know when. You have to go in the hospital at odd hours. And I've been doing this for over 16 years, closer to 20 years with my fellowship, and I've never had an issue with any kind of problem like this. So, that's it.
All right, thank you, sir. This will be an opportunity for any questions by the panel members. Can we start with Ms. Sutton Willis? Do you have any questions?
I did have a question. Counsel, you mentioned something about the completion of a professionalism program. Why?
To address just the general unprofessional conduct findings here, and the professionalism program is designed to reinforce concepts of professionalism and adherence to laws and regulations.
Counsel, for Dr. Casal, in the case that you mentioned at 96 Calat,
Ma'am, could you please pull your microphone toward yourself?
at 96 Calat 44-757, it states that substantial, it's partially depublished, I think, also. But it does say that substantial legal authority provides that conduct occurring outside the practice of medicine may form the basis for imposing discipline on a license.
It's a good question.
Yeah,
It's
where I'm going with that.
Yes, I'm glad you asked it. So, Dr. Griffiths came in and said, you can't take action against me because even though I've had 3 DUIs and there's evidence of a problem with alcohol, I never had a problem at work. And the board said, and his attorneys said, well, there's enough of a problem here and your lack of insight that we don't want to wait for a problem. And what the Court of Appeal was addressing was the argument that the case doesn't have to involve the practice of medicine if it could affect the practice of medicine. So it's very important to distinguish the fact that it really showed that Dr. Griffiths was out of control. And he also sought to invalidate the conclusive presumption of 2239A that said more than one misdemeanor is conclusively presumed to be substantially related, and the Court of Appeal refused to break that conclusive presumption. It's unfortunate, and only the lawyers here are really going to appreciate this, but this is a case of dicta gone far. So the dicta in that case is that one of the reasons for the justifications for the court's action is that there's lack of judgment involved. And that term has been taken from that case and applied to every doctor who has a DUI and said they didn't have good judgment. Okay, it's true. No DUI situation is good judgment. But the court was, in that case, was not talking about just any bad judgment of any doctor. They were talking about the fact that this doctor had the bad judgment to not get treatment, to continue his lifestyle and the problems.
Are you making the argument, though, that this doctor is uniquely situated to be seen as fit to practice without these restrictions, or that or are you making the argument that the single conviction should not be seen as? Where are you on
Just for
this?
clarification, the purpose of the hearing is to address the penalty. Judge Anderson has determined that the conduct was substantially related, so we are looking at the penalty.
Well, I want to answer that question, though, which is I argued both. I've been arguing both. I've been arguing both that this case isn't substantially related, and especially when you look at Dr. Hasselt and his history, the fact that he's been on call, showing up in the middle of the night, that there's so much evidence that he doesn't have a problem with alcohol that creates a danger to the public that affects his fitness to practice medicine. But I am arguing as well that Griffiths doesn't apply to the case of a single DUI, and that 2239 does not make every DUI a cause for discipline unless it is substantially related.
Dr. Levine? No questions. Ms. Blossom?
I do have let me, actually, I think I do have a question for complainants counsel, which is, you've argued for monitoring and oversight, and I think I need a little bit more detail on why you think that over time would ensure that Dr. Posselt has the requisite good judgment, because I do think this is a case about good judgment. There's no evidence, as far as I can tell in the record, that there's a substance abuse problem. So how is it that if we monitor him for a substance abuse problem, are we demonstrating to the public that he has the requisite good judgment to continue to practice medicine?
And that is why I suggested a short period, a discrete period of time to address any potential concerns that, and to address any concerns that this is indeed an isolated incident, albeit kind of an extreme example of an isolated incident of drinking and driving. But that's why we also recommended that it be coupled with a professionalism program which should reinforce the exercise of judgment and professional judgment. We don't have an ideal, there is no pill that, or program that you can take and suddenly judgment is intact. But I believe that the guidelines do contain some of these tools because they do serve to reinforce and to support good judgment.
Dr. Bullock?
I have no questions.
Ms. Pine?
I have no questions.
Dr. Conrad?
Thank you, Dr. Posselt. You put a 10-year-old kid at risk, and you put public at risk. You're an accomplished, outstanding surgeon. What have you done since then so that it will never happen again?
I've changed everything around. I'm extremely, I'm not drinking, but I'm extremely aware of issues associated with drinking and driving. I have gone to rehab as required. I think overall I'm just much more aware of the wrongness of the situation that I was in, and I want to make sure I'm never in that situation again. I wasn't intending on getting drunk that night. I wasn't really paying that much attention to what was being served, and I felt relatively okay when I left, and I think as I was driving home I got worse and worse, and I think that was the mistake, was drinking in the first place. I'll never do that again. I mean, that's all I can say. I'm not, it's not never going to happen again.
I gather from your attorneys that that week you were off, is that correct?
Yes.
Okay.
Yeah.
Dr. Krause?
No comment.
All right, thank you. Any further questions from the panel? All right, at this time, then this concludes the oral argument. The record is closed. The case is going to be deliberated by the panel in closed session. Operator.
Thank you.
Thank you.
And for counsel, the court.
Morning, everyone. Welcome to Panel B, Medical Board of California, January 26th meeting. And we'd like to get started with our roll call, please.
Ms. Lawson?
Here.
Dr. Bonadette?
Here.
Dr. Kraus?
Present.
Dr. Levine?
Here.
Ms. Pines? Here. Ms. Sutton-Wills?
Here.
Dr. Bullock?
Here.
We have a quorum.
Thank you very much. I'd like to welcome our Judge Lynn Willard, who will be presiding over our panel.
Good morning. We're on the record before the Medical Board of California in Office of Administrative Hearings, case 2016-120990, Today is January 26, 2017, and we have established that there's a quorum here today. May I have the appearances of the Deputy Attorney General?
Good morning, Maura Faust, Deputy Attorney General.
And 4 respondents.
M. Bradley Wishick for Dr. Saidi, who is present.
Good morning. In this matter, the board has issued an order of non-adoption of a proposed decision by ALJ Koch-Goodman and has decided to determine the matter itself. The board has instructed that oral argument shall be directed only to the question of whether the proposed penalty should be modified. The following time limits will apply. The respondent will have 15 minutes to make an opening argument. The Deputy Attorney General will then have 15 minutes for a response. The respondent will have 5 minutes for a closing, and the Deputy Attorney General will also have 5 minutes for closing argument. The time limits will be strictly enforced, and I'll give you a 2-minute warning. The argument shall be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence shall be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions to elicit new evidence. The administrative law judge and any panel members may ask the party to support the party's oral argument on a matter with a specific citation to the record. At the end of the oral arguments, I will offer respondent an opportunity to address the panel directly if you should so choose, and if you do so, sir, I will place you under oath to enable that to occur. After the oral argument, the board will go into a closed session to deliberate. There will be no decision issued today. You will receive your final decision in the mail in the future. Again, please remember that all the arguments are based on existing record, and the board has already had the benefit of reading your briefs. At this time, respondent may begin his opening.
Thank you very much. Good morning. My name is Brad Wishick, and I have the privilege and the honor to represent Dr. Said Saidi. I thought that my job was hard, particularly that my job was hard in this case because it involved thousands of pages of medical records and exhibits and countless witnesses, hours of preparation, and of course many days of hearing and testimony. As I was preparing for this argument and preparing the brief after the non-adoption order, it occurred to me that the job that members of the board have, this panel, is harder than my job. Each of you have a limited amount of time to devote to this as in the spirit of public service. You have other jobs, and you have other professional responsibilities, and only so much time to devote to the cases, and this is not the only case that you have. And so it occurred to me that in order to do this, you must, of course, give great deference to the findings that have been made by the administrative law judge in the cases that you review. And in this case, we had a judge, Judge Koch-Goodman, who was very diligent, took copious notes, wrote a very detailed decision with factual findings and conclusions that was some 40 pages. That must be of substantial assistance. And as I was trying to think about the deference that you're required by law to give great deference to the judge's findings, how I might illustrate why that's a good rule. And I came across a law review article that was written by a federal administrative judge by the name of James Timoney. And it's on the subject of demeanor and credibility. And he began it with the most unusual vignette, which was taken from that legal drama, My Cousin Vinny. And it begins in this way. Tony, why are you arresting me? Sheriff, because we think that you shot the store clerk. Tony, I shot the store clerk. Sheriff, you shot the store clerk? Tony, I shot the store clerk. Sheriff, I knew you would confess. What he goes on to explain is that witnesses may use irony, sarcasm to convey their meaning. The written transcript cannot reflect all the subtleties of witnesses, such as an inflection of voice or a particular gesture that may completely change the meaning of the testimony. Often the sincerity of the witness may be observed only from the way the witness sounds or looks. When the sheriff accused him of shooting the clerk, Tony expressed disbelief because he had in fact not shot the store clerk. A reading, however, the transcript without the benefit of observing the accused's demeanor might give the fact finder the impression that the accused has confessed. To fully judge the witness's testimony, the fact finder must see and hear the witness's demeanor. So, in this case, I do believe that the judge did a remarkably good job. And I also have to say that I have to assume that when the members of the board saw this decision, given the nature of the allegations, which are so serious, that it surely must have struck a chord in terms of we need to look at this decision quite carefully. And I think that Judge Coach Goodman was able really to do an extraordinary job of taking away the emotion and looking at the facts and details to come to these factual findings. I think that was not the case with some of the board's witnesses, including Dr. Terrell, who was so prejudiced by the material he reviewed without seeing or hearing or talking to the witnesses. And the same thing with Dr. Gerhardt, the board's other expert. But I also want to make clear, I'm not going to suggest that I agree with every finding that Judge Coach Goodman made. But that's not my place here today. I was an advocate. There are certain things that I disagree with that I think the evidence points otherwise, but I have to accept. Dr. Zadie has to accept. The board's counsel has to accept that these are the findings that Judge Coach Goodman made. And those findings are what guide what's going to be the penalty, or in this case, I'm asking that no penalty be imposed, that the accusation be withdrawn, because in some respects, the findings and the conclusions are simply not supported by the record. So I want to begin with trying to simplify what I think the issue is from Dr. Zadie's perspective today. If you look at the decision that was made by Judge Coach Goodman, she concluded that Dr. Terrell's opinion was not entitled to be relied upon, that it failed to meet the standard to establish that Dr. Zadie suffered from a medical or mental health condition that would make him unfit or unsafe to practice. So those issues are out of the case. There are really only 4 findings that are at issue. And I want to point out that the board's counsel does not disagree with that position. And in the brief that was filed after non-adoption by the board's counsel, at page 2, beginning at line 4, board's counsel said, administrative law judge Erin Coach Goodman was within her discretion, and the state of the evidence was such as to cause the ALJ to discount Dr. Harold Terrell's findings on his Business and Profession Code section 820-822 psychiatric examination. So really, what I'd like to discuss for a moment are the 4 findings that were relied upon in Judge Coach Goodman's decision to support any discipline at all. There were 4 findings that she made after rejecting most of the allegations that had been presented to the board that all related to the standard of care. Those findings are set out in her decision on page 31, and the findings that she found a deviation from the standard of care contained in paragraphs 6, 7, 9, and 11. For simplicity's sake, they involve 2 patients. Their initials are RG and JER. I want to begin with the records violations that Judge Coach Goodman found. As to both of these patients, while I think the record might have supported otherwise, Judge Coach Goodman found that the chaperone was not in the room for the entire examination, but only the beginning of the examination as to both of the patients. So she then concluded that the standard of care for medical record keeping requires that the records be complete and thorough. And she concluded that Dr. Zadie's failure to chart that the chaperone was in the room for a portion of that time, therefore, was a deviation from the standard of care. There are 2 significant problems with this. The first is that Dr. Zadie was never accused of a violation of the standard of care with regard to the keeping of medical records. The violation that was alleged was that he had been dishonest and had misrepresented in those medical records what had occurred. In the report of Dr. Gerhardt is contained in Exhibit 40, where she did a supplemental report addressing what was identified as the falsification of medical records. If you look at Exhibit 40, she comes to a conclusion regarding Dr. Zaidi, allegedly based upon the testimony, or I should say the record she reviewed of the witnesses, that Dr. Zaidi had misrepresented, or if he had, their chief complaints. That was a departure from the standard of care. If he omitted reporting elements of the examinations that he did, that was a departure from the standard of care. And that reporting a diagnosis of a skin neoplasm when he did not see it would be a departure from the standard of care. That was the issue that was presented. That was the allegation in the accusation. That was what the lawyers questioned Dr. Gerhardt about. There was no allegation of a departure from the standard of care with regard to the medical record keeping. The allegation was that he was dishonest. The judge actually found, Judge Koch-Goodman, in her findings, that Dr. Zaidi was dishonest, but followed that with the finding that he had no intention to mislead or to conceal. They're totally inconsistent. That is not the allegation. The finding or the allegation was that he was dishonest. She made a factual finding he was not. The standard of care finding she made is not what Dr. Zaidi was accused of. But more fundamentally, there is not only no evidence in the record that a failure to chart the length or duration of the chaperone in the room is a violation of the standard of care, but just the opposite. And I must apologize because Ms. Faust let me know this morning that I had failed to obtain the complete record of transcripts because of the expense. I have a transcript of Dr. Gerhardt's testimony, which we obtained after the after the testimony, which has different pagination than the one that the board has. And so I can tell you that beginning on the 67th page of her testimony, which will have a different number in your record, I apologize, beginning at line 19, these were the questions and answers. Now, the patient represented that the chaperone was only present for part of the exam. Is that right? And by the way, this relates to JER. Answer, correct. Question, and again, if there was an exam during a period of time when the chaperone wasn't present, should that have been documented in the record? Answer, actually, let me add to that. In this case, the patient actually asked for the chaperone, and at a later point of the exam was told the chaperone was busy. I interjected and said, I'm assuming that's a hypothetical. Ms. Faust said yes, and the witness continued. I think it's wrong to not have a chaperone present when someone is undressed. As far as documenting the minutes that the chaperone was present in the room, doctors don't do that. I think maybe it should be done, but they don't. The only evidence that is in this record before the board is that it is not a violation of the standard of care to not document the length of particular time that the chaperone is in the room. 2 of those 4 findings related to standard of care simply cannot be sustained on this record and are contrary to the evidence that was before Judge Kochman. The other issue has to do with standard of care as to the examinations that were done of RG and JER. And this is addressed in the brief that we filed after the non-adoption. I simply want to say that what's surprising about the decision is Dr. Gerhardt, the allegations and the accusation, and counsel in addressing them always assumed that the judge would either find that these patients were completely naked when they were examined or that they were not. There were no questions posed to Dr. Gerhardt, nor would we have occasion to think that we should, regarding whether if a skin exam was done where the patients were gowned, draped, or a musculoskeletal exam, would that violate the standard of care? But that's what Judge Koch-Goodman found. She found that JER was in a gown and had a drape on when the musculoskeletal exam was done and when the examination was done of her skin, and said certainly that the doctor had done what was his practice, she assumed, which was to expose parts of the skin and to look at them as part of the skin exam. Exactly what the testimony is of Dr. Gerhardt, that is an appropriate exam. The same problem exists with regard to Ms. RG. Her own husband testified that it was possibly the case that she still had the gown on and that it was moved to look at her skin and that she had a drape around her at the time of the skin examination. So what happened is the judge found that the testimony of these women was simply incorrect and found that they were in fact, as to JER, in a gown and a drape at the time of the examination, found that RG was at least in a drape at the time of the examination.
One minute.
Thank you. And that that was a violation of the standard of care. But that was not the allegation in the accusation. The lawyers, understandably, because we did not anticipate that there would be a finding that the patients were gowned, but that was something that might be considered a standard of care violation, did not question Dr. Gerhardt and did not address that issue. There is not any opinion, expert opinion in this record that supports the idea that the examination done by Dr. Zadie, as found by Judge Kosh Goodman, violated the standard of care. And to the extent that you look at the testimony of Dr. Gerhardt and Dr. Pont, it actually is supported because the examination was done by looking at them in a gowned situation and moving portions of that to examine the skin, exactly how Dr. Gerhardt said such an exam should be done.
Thank you. Ms. Faust.
Good morning, ladies and gentlemen of the board. The key issue here is the examinations, naked skin examinations of patients JE and RG. And Judge Coach Goodman missed or didn't fully get all of the facts. The board can decide and modify its decision based on the record. It is not tied specifically to each and every one of her findings. More specifically, the two patients, while she found them to be credible, she used the words mostly or nearly naked when the evidence showed both patients were completely naked during the skin exams. We have two patients who did not know each other, that were not involved in any civil lawsuits, and appeared to be credible. Patient JE said that she was examined naked while standing and that she had her vagina exposed while lying down. And that's in my brief at page 5, the references to the record. Patient RG said the respondent had her twirl while naked. Now the husband said 3 different things, and this is many years later, and he was a little less clear. But first he said that she was initially gowned naked to the waist down. That's at page 266 of the transcript on March the 17th. And that once the chaperone left, she was asked to stand up and take her gown off and circled completely naked. Then on cross-examination, he was asked, is it possible that when she was standing up and asked to twirl around that she might have been holding a drape? And he said he believed it was possible. He wasn't sure. But then on redirect, when he was asked, and this is at page 280 of that same transcript, do you know whether at some point whether the drape was removed as well? He said yes. And then I asked at what point, and he said when she was asked to stand up and do the whole body examination. So looking at the complete record, he supports his wife's record that she was completely naked when turning around for that skin exam. The other thing the judge failed to comment on was Dr. Slapnick's testimony. Now, who is Dr. Slapnick? He is the head of the UC Davis medical group. He did an internal investigation where he called in Dr. Zadie to interview him about this issue. Remember, Dr. Zaidi gave no statement to the medical board at all, testified at this hearing he had no memory of these exams. Yet when Dr. Slapnick interviewed him shortly after the incident, he admitted to Dr. Slapnick that he did 2 complete naked skin exams. Later, Dr. Zaidi denied that, but Dr. Slapnick had no reason to misremember shortly after the fact that his employee admitted to doing 2 naked exams. And so, with that, we would ask that in terms of the decision, that at page 25 of the decision, the second to last line, when the judge says, for RG, she was standing nearly naked, we would ask that you strike the word nearly. At page 26, well, let me digress for a second. We have the testimony of Nicole Eichenberg. She was the MA on JE's exam. And her initial statement as part of the UC Davis investigation was at Exhibit 8, page 47. And this was taken on 4/9 of 2013, well before she testified at this hearing. And what does she say in that statement? That she roomed the patient had her clothes on, and then she left. She came back sometime later, and at that time, the patient was gowned, no underwear bra, just in a gown. And she was in a gown and a drape, and I asked her if the doctor was done, and the patient said to her he was coming back to examine her, so I closed the door and went back to my desk to continue working. He, meaning Dr. Zaidi, called me back into the room after a while to chaperone, and he examined her, pressed on her back, had her arms against his in several directions. That's an upper musculoskeletal test. There's no reference to a lower musculoskeletal exam. So when she's in the room, there's no mention of leg movement in this statement from 4/9 of 2013. Okay, then she says, he signaled to me when he was ready to have me leave the room. He says thank you and nods, so I left the room after he gave me the signal. The patient is still gowned without underwear or a bra, and she's gone for a while, and we don't know what happens after that. She says, I don't know how long he stayed in the room after that, because the last 2 hours of the day was that's her statement soon after. Now, on testimony on cross, she says there may have been a lower skeletal exam while she was there. She wasn't really sure. Counsel's latching onto that to try and say there was no period where there wasn't chaperoning. If you actually look at her full statement shortly after, there's long periods where she's not chaperoning. And again, we have Slapnick saying, we have a naked exam, and that the respondent is admitting to that. So with respect to the other findings by Judge Koch-Goodman, we do have a skin exam that's not chaperoned at page 26 of her findings, but at 31, the following changes need to be made. At paragraph 6, the almost naked exam for JER should say naked. The almost should go. And at paragraph 9, the almost completely naked turnaround should be completely naked. With those 2 changes, there's sufficient evidence that Dr. Zaidi violated the standard of care in having 2 naked skin exams that he couldn't recall, but he admitted to doing with the head of the medical group. And with that admission, while it is true we're not going to use Dr. Terrell's findings, that's gone, that ship has sailed. What is allowable under the guidelines is to put him on probation, require that a chaperone stay, the full exam for any female, that he take another psych eval, that he do therapy, that he take a boundaries course, an ethics course, and that we have a period of probation to make sure that he learns not to do full naked skin exam. I believe in the judge's decision there may also be a CME in relationship to how to do an exam. Yeah, there's a condition for an education course. So all of her, the penalty is right. was she made the mistake with these words of almost or nearly. Those words have got to go. And leaving out Dr. Slapnick's findings that he admitted, the respondent admitted to him, I did completely naked skin exams, which is wholly inappropriate. And I believe that's all, because cutting to the chase, oh, actually, with respect to the records, let's talk about Dr. Gerhardt and the records. So Dr. Gerhardt did give an opinion that he was dishonest in J.E.'s record, but it's a combined opinion, which the judge may be parsing out. Her opinion was that the dishonesty was the failure to chart the breast exam, the fact that he opened and closed her legs when her vagina was exposed, and the fact that there was no chaperone in the room. She didn't make a finding as to one, it's a combined finding. That's how it's pled, that's how she gave her opinion. You'll see the reference in the brief. And so the judge's finding specifically to chaperoning may not be strictly accurate. I don't know that it matters. I think as long as there are findings with respect to extreme departure from the standard of care on the naked skin exams of the two patients, that is all you need to get the penalty in this case. Thank you.
Any response? You have 5 minutes.
Thank you. With respect to the board's counsel, she is asking you to do exactly what I don't think can be done for the reasons that I just have addressed. She's asking you to hear Tony saying, I shot the clerk, and hear it as a confession when you were not there to judge the credibility of these witnesses. I am not coming before you and trying to convince you, though I have indicated I disagree, for example, that there was not a chaperone in the room for the entire time. There is a mountain of evidence from which I could argue to you that that was the case. We had our opportunity to do that before Judge Koch-Goodman, and she judged the credibility of the witnesses, and she made these findings. I cannot imagine how we could go back and cross out the words nearly naked, or they felt naked, or functionally naked. And she has said, for example, with regard to JER and her findings, that she had a gown on and that she had a drape on. That is what the judge found. Counsel for the board is picking out things that she was able to argue and did to Judge Koch-Goodman that were rejected. And what you have to remember is, it's not enough to say there's evidence in the record. Surely, each of these women testified that they were naked. But Judge Koch-Goodman did not accept that testimony. These same women testified under oath as to RG that she had come to see Dr. Zaidi for nothing more than to get thyroid medication, and that Dr. Zaidi insisted on doing a pelvic exam and a breast exam when that was not what she wanted. That was one of the allegations. And Judge Koch-Goodman went through this evidence, watched the witnesses, evaluated their credibility, and said, that is not what the record shows. She came here for a well-woman examination. RG was not even able to testify as to the reason that she came to see Dr. Zaidi. These are the reasons why we can't cross out words that are findings that a judge made from all of this contested evidence in these proceedings. The same thing is true with regard to JER. JER testified that Dr. Zaidi tore the drape from around her and said, I'm not done doing this examination. She testified that Dr. Zaidi did a breast examination of her at one point when she was standing up and another point when she was lying on the table. She testified that Dr. Zaidi had grabbed her buttocks at one point during this examination. And the judge who saw and heard the testimony of Dr. Zaidi for nearly a day, who saw and heard the testimony of the people who worked with him, who talked about his character and who he is, who considered the communication issues that are in the record, where he was not the best communicator at the time of these examinations and has worked hard to improve that, and considered the demeanor and manner of these witnesses. And she found those things that these women testified to under oath never happened. So that's not to say that we are saying, and Judge Coach Goodman certainly did not find that they are liars or perjurers. What she found is that this experience for them was something where they felt that something hadn't happened correctly. A matter of communication that the doctor was working hard to fix. But what you, I think, cannot do is disregard the careful, hard work that Judge Coach Goodman did and the deference that the law requires and our common sense, if you think about my cousin Benny, in giving to the judge. If there is credible evidence in this record that supports her findings, then surely you must defer to her because she had the opportunity to evaluate this and sift through this in great detail and did a very good job. Where there is no evidence in the record or where the evidence is on another point and they are not the actual allegations that she found, in those regards, I am suggesting that the findings that she made are not supported by the record. And for those reasons, I am asking that the accusation be dismissed.
Thank you. Did you have another point yourself?
I do apologize. When Board's counsel was talking about these things, I could get into the weeds and talk to you about all the other evidence. When she says that Dr. Zaidi had said to Dr. Slapnick that the patients were turned around naked, the truth is that in that testimony he acknowledged he might have been mistaken. And what you did not hear from the Board's counsel is that Dr. Ty Arnett was present and said he never heard that.
Any response?
Yes, so Dr. Arnett was also a character witness for Dr. Zaidi. He was his immediate supervisor. He went to bat for him repeatedly on a number of issues, including prior complaints. He didn't recall any of the discussion that Dr. Slapnick recalled. And you can look at Dr. Slapnick's full testimony. I would urge you to do that. But the judge didn't comment on it at all. It was a multi-day hearing over a better course of a year, and she actually doesn't reference the Slapnick testimony at all. The board has two choices if there's disagreement with Judge Koch Goodman's decision. You can either make technical or minor changes under 11517C, and if striking out nearly and almost or minor technical changes, that's one way you can go. Alternatively, you can reject the proposed decision, start over from scratch, and decide the case on transcripts and exhibits. However, if the panel decides to do that, I would urge you not to go back on the 820-822 Dr. Terrell aspects of this case, and merely stick to the naked skin exams. But you have either option. It's well within your power under the non-adoption statute, and I would urge you to maintain this penalty, but with the understanding that the evidence shows 2 naked skin exams. Thank you.
Thank you. Does respondent care to address the panel? Do you care to address the panel?
Just want to say that.
May I ask you to please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony about to give in this proceeding will be the truth and the whole truth?
I do.
Yeah.
I was not actually prepared. That my attorney told me that you guys are not going to ask me any questions, but I just want to say I have gone through a lot of trauma. My family, we have suffered, and I feel sorry for these patients. I truly do. I honestly feel sorry that they went through a lot and suffering. It was never my intention in these examinations for any sexual gratification or anything like this. I was doing what I was taught in my education, how to do a thorough exams. I am known for those. I mean, before the judge, everybody testified. I've worked different clinics. Many people, they've seen me, doctors, nurses, MAs. It's never, ever, I never thought that this is what's going on through these patients' minds. And so it was a shock for me. Unfortunately, when the first time, I'm not blaming anybody, when the first time these complaints were made, everybody told me like you need to use more chaperone, have a low threshold and all that, and I changed my practice. You know, that's all the evidence is there. Nobody talked to me the real problem there was not just the chaperone, but to develop a rapport or more like a good communication with the patient so that they can start trusting you. That is what I did after these complaints were made, the last 2 complaints, and I worked for 2 years after those complaints. Thank God for that. Alhamdulillah, there's nothing that happened in a way that, any such complaints were made. I have changed the practice. As I said, I feel really sorry for these women. They came to me for getting good help, good care. I did not provide them good care, I admit that. But I just want to say that I've already gone through a lot. This whole trial has gone through for a year. It's been 3 or 4 years. My family has gone through a lot. Not working for 2 years, so I don't know what else I can do. I've worked so much on that nothing like this ever happened again.
Thank you. Any questions from the panel? Again? No questions. Any questions? Dr. Cross?
Doctor, could you describe for us the methodology which you presently use in doing full skin exam?
So, I'm not working for a couple of years now, but the 2 years that I worked after these 2 complaints, I have actually started making more of a rapport with the patient. My wife is sitting there, she's also a doctor, and so as you can imagine, at the end of the day, we would chat about different patients, and I had an interesting case and all that. And I always would say, like, Fatima, why do you spend so much time with these patients? She would ask about how's your game grade, how's your allocations, how the stuff going on in your life. And I would say that this is a waste of time. Why do you do that? Go to the next patient, start doing the more And she would say, no, Syed, this is what matters. It's the communication. It's how you develop a rapport and trust with the patient. I never believed that. I continued doing just like a robot. All the MAs, all the doctors would tell you this. I did things that, I was taught in the books in the med school, but not developing a rapport. So as you ask, like what I have done now, my methodology is to develop a rapport, to make patients believe that I am there for them, to help them, so that they can start trusting me. If there was a trust issue there, if there was no trust issue there with these patients, they would never thought anything like this. The first complaint when I had, or the second one, when she brought her husband with her and she was there, if I had a good trust relationship with her, she would have told me, Dr. Zaidi, you know what, I don't feel comfortable, why did you do that? I mean, the problem here is she was not open to that. And the reason was because she was not trusting me. And that's what my methodology now is for the 2 years that I worked after that I started working on those 2 issues. That I have to communicate and I have to win their trust. I don't have to just, do a robot thing and buy the book and, no communication at all. If you are asking about the exact skin exams,
Yes, what is the methodology you would presently employ in doing a well-person full skin examination?
well, it's more of an integrated exam that I do. I certainly have a chaperone present if there is any female exam is done. And then I would start from part to part as I've been using it, that if I have to, the patient would be in gown and drape. And then if I have to do, if I'm listening to the auscultating, and so at that time, I'm doing the skin exam as well. I would not do it as a separate exam, first of all. The second thing is that I would ask them, communicate with them if they are okay with that, examining that part of the body or not. Part by part, first of like the right side, front, anteriorly, and then the left side, anteriorly, then the posterior part, and then, so it would be more like part by part, and more like integrated exam. So I would talk to them if I see a mole that, this looks suspicious, so why don't we talk to a dermatologist? So that's how I've changed. Certainly, I do not ask the patient, and this was, a practice that I stopped totally, that, can you turn around? I would rather go at their back and then, examine them. As I said, thank God, after these allegations, I had, I don't know, hundreds of thousands of patients that I saw, not thousands, but hundreds maybe, that I did the skin exams, the well woman exams, I never had an issue like that.
Thank you.
Any further questions? All right, thank you. At this time, then, the oral argument is concluded. The panel will go into closed session to deliberate. You will receive your final decision in the mail. Thank you very much, sir.
Thank you.